Senator Wright.
Yes, thank you, Madam Acting Deputy President. I rise to speak on this disallowance motion of the government's court fees, which I have co-sponsored with Senator Collins and the Labor Party today. As everyone in this place would be aware, on 24th of June this year, I moved a successful disallowance motion as the Legal Affairs spokesperson on behalf of the Australian Greens that should have put an end to this government's blatant attempt to raise revenue at the expense of family court users, including women and families at risk of violence. It should have knocked out once and for all this government's greedy and cruel divorce tax, their way of slugging people going through family breakdown a further $350 to obtain a divorce. But sadly, in an almost unbelievable act of, and I won't use pejorative, I will use pejorative terms, but I won't use swear words, but people might know what I mean, but certainly legal trickery and cynical politics, this government and the Attorney-General has tabled almost exactly the same regulation that was voted down by the Senate, which would increase the same range of family court fees to the same extent, but with the addition of a further $5 in some cases. So at best, this is a flagrant disregard of the decision of this Senate, and at worst, it's an illegitimate attempt to reintroduce a regulation that's the same in substance as that which was disallowed on the 24th of June 2015. So the opposition, the Labor Party, is currently testing the legality of the government's actions in the federal court. I predict that the court will find that the regulation that was reintroduced by the government will be substantially similar to the regulation that was previously disallowed, and I predict that it will be struck down by the court. In the meantime, however, of course, this move by the government has created confusion, chaos, and countless families in breakdown have been paying hundreds of dollars more at registries across Australia to access legal services that they and their children need. What a way to do business. What a way for the Attorney-General, the principal legal officer in this country, to act. Family court registries are suffering under the serious and confusing uncertainty this government's legal trickery has brought with it. And in fact, the day that the regulation was introduced, there was chaos in the registries as people turned up expecting to be paying one thing because of being aware of the decision by the Senate to disallow the previous regulation, and having to be informed by hapless court staff that indeed the cost had gone up again. So the fees went up, they went back down again, they've gone up again, and now, with this, if this disallowance is passed, they will go down again. How is this fair? How is this clear? How is this an appropriate way to run the country? What does this achieve? How long will it go on? Surely now it's time for the government to act decisively on this issue. It's time to offer clarity to families using the family court who are already in a state of distress, often because of the circumstances that are bringing them to the necessity to rely on the court. How will it bring clarity to families? It's important that they understand the fees won't go up by 40% and bounce around again while the government works out another way to sidestep the law and the clear will of the Senate. But perhaps I should remind everyone in this place why the issue at the base of this, the cost of access to justice, is so important. And that's because we know that the cost of legal proceedings, the cost of access to the law, is the most common barrier for people in Australia now seeking legal help, and court fees are already too high. When it comes to accessing justice, which is a fundamental aspect of having a country where rule of law is respected, that people can get equal access irrespective of the size of their wallet and only based on the merit of their claim, the people are being failed by this government's policies and funding decisions. And it's not just those who are suspected of or charged with some kind of wrongdoing or an offence. These people that are now having trouble accessing basic justice include the most vulnerable and innocent among us, such as children who are experiencing poverty and family violence, or women experiencing domestic or sexual violence, for instance, in remote communities. They also include the most ordinary people among us, families who want to clarify guardianship arrangements for their elderly parents, divorcing couples who are wanting to finalise property settlements or arrangements for care of their children, neighbourhoods who are seeking to protect their local environment from harm or degradation. Over and over again, under this government, we have seen cruel and counterproductive funding cuts that slice away at the fabric of access to justice in Australia, totalling well over $40 million since the election of this government. We've seen community legal centres and legal assistance services forced to turn more and more people away who are in need. We've seen courts and tribunals who felt the squeeze of efficiency, so-called efficiency strategies. What is efficient about forcing people into a situation where they have to be self-represented or are not able to access justice at all, with the flow-on costs that come from unmet legal need, beggars my understanding. There's nothing efficient about that at all. We're seeing mandatory sentencing policies and other legislative changes which are designed to remove lawyers and limit judicial discretion. This is the form that this particular government has. This is the form that this Attorney-General has. The result is, at best, a cruel and confusing system that fails to take into account individual experiences and leaves people in Australia without the help they need to understand what the law is, how the system works, and leaving us with a system that leads to unfair outcomes, particularly for those who aren't privileged enough to obtain private legal advice, leaving young people institutionalised, families torn apart, and children at risk. Let's cast our minds back. In 2013, the Senate Legal and Constitutional Affairs References Committee, which I chaired at the time, commenced an inquiry that was initiated by the Australian Greens into the impact under the previous Labor government of higher federal court fees on access to justice. There was a great deal of interest in the inquiry from the legal community, and a large number of submissions were received. The overwhelming consensus for participants in the inquiry was that the fee increases at that time were largely unreasonable and inhibited access to justice. Indeed, it's very interesting to note that the then Shadow Attorney-General, Senator George Brandis, went out and decried the Labor government court fee increases, and in fact was talking about the then Labor government's disguised divorce tax. So he was very, very loud and vociferous at the time about using the courts as a revenue-raising measure. However, interestingly enough too, as a result of the inquiry and the submissions and the evidence before us, the Australian Greens made a primary recommendation in our report from that inquiry that the 2013 fee increases should be wound back to the level which prevailed prior to the 1st of January 2013. But despite the Shadow Attorney-General George Brandis's grandstanding at the time, in fact, the opposition at the time would not sign up to those recommendations. Don't look at what they do, look at what they say. That's what they'd have us believe, but in fact, look at what they do. Despite widespread acknowledgement that rising court fees were hindering access to justice, not one of the Legal and Constitutional Affairs References Committee recommendations from the 2013 court fees inquiry that came about from that inquiry have been implemented. This includes a recommendation that relevant stakeholders from the courts and the legal profession should be consulted before any future changes to federal court fees. We also discovered that in the 2013 inquiry that some federal court filing fees have tripled over recent years. This is nothing but a revenue-raising measure and an unfair tax on people who are unlucky enough to have to use the court system. And yet here we are with this government now proposing further increases to court fees up to 40% in some cases. The Australian Greens were particularly concerned about the $350 increase to divorce applications and the potential impact of that on women trying to leave domestic violence and family violence situations. People will understand there's a lot of discussion about family violence and there's a lot of rhetoric from the current government about the need to act. But when we look at the actual practical implications of an increase like this, which will impede some women who need the closure of a divorce to end a violent relationship, when it will impede their ability to get that, you have to again say, look not at or listen not to what they say, look at what they do. So we've seen with the government fee increases the cost of divorce applications from $845 to $1,195 in the first tranche of regulations, and of course that will even be slightly higher under this second regulation that the government has now tabled. This will cause excessive and unfair delays to victims of domestic violence who will be seeking a divorce. In fact, the 2013 Senate inquiry into court fee increases found that high court costs were indeed dissuading women who were trying to leave abusive marriages, and there's evidence in that committee report for anyone who's interested in looking at it. At a time when family violence is clearly on the national agenda, and rightly so, we must be making every effort as a community and as a parliament to protect victims of domestic violence and ensure that they have access to legal advice and to the courts. We have to put an end to the scourge of family violence in this country, and increasing divorce applications by $350 or more will make it even more difficult for women in abusive marriages to leave. The changes to these family court fees, and particularly the divorce application fee, are particularly cynical when you actually realise there is no option for divorcing parties to avoid the courts. It's not as if they can be encouraged to somehow settle their legal differences or their legal claim in any other way. The only way to get a divorce in Australia is to go to the family court, make an application and pay for it. So even when they reach an agreement, even when there's consent orders, there's a fee imposed and there's an increased fee now under these government regulations. The Australian Greens say it is completely inappropriate for the government to use family breakdown as a cash cow. And while the government has tried to justify these huge fee hikes by suggesting that the money will go to improving court facilities, looking at the truth of the situation, only a minor proportion of the $87 million that was predicted to be raised will actually be reinvested in the courts. Only $30 million will be spent on improvements to holding cells and to the safety of child dispute conference areas. Many legal stakeholders have opposed the fee increases on the grounds that they will significantly impact on low to middle income Australians and small to medium-sized businesses that don't qualify for legal aid or any fee exemption or waiver. They also say these are unreasonably large and not justified by any rational policy objective, because really it's just about raising revenue. They're not supported by evidence that changes to fees will advance the government's policy objectives. Legal stakeholders say that these fees will impose an unreasonable barrier to accessing justice by making access to the federal courts contingent upon the capacity of litigants of various means to meet the substantial additional cost of litigating. There will be impacts upon litigants inequitably, and they will establish a regime which disproportionately impacts on those who have more limited financial means. So we will move increasingly to an Australia where justice is as good as you can buy, as good as you can afford, irrespective of the merits of your case. So, on that basis, I want to conclude by saying that I urge everyone in this place to support this disallowance and to remain resolute in their commitment not to let this arrogant and unprincipled government take us and the users of the family court for granted.